Hello, and welcome to Disability Rights Maine's Adult Brain Injury and Developmental Services Grievance Process Training. My name is Megan Salvin, and I'm a managing attorney with our PAD team at Disability Rights Maine. I am joined with my coworker, Kyle Pelletier.
Hi, everyone. My name's Kyle Pelletier, part-time outreach coordinator for Northern Maine.
As all of our trainings, this training should be considered for educational purposes only, and it should not be considered as legal advice, nor is it offered as such.
Our mission, disability rights in Maine, advocates justice and equality by enforcing rights and expanding opportunities for people with disabilities in Maine. Who we are, part of a national network of protection and advocacy organization, PNAS, a nonprofit agencies with a volunteer board of directors. At least 51% of the board must be people with disabilities. Maine's only cross-disability advocacy organization operated statewide.
Some key priority areas that Disability Rights Maine focuses on is we work to eliminate abuse, neglect, and exploitation, especially in facilities, reduce the use of guardianship, and improve access to disability-related support services, including access to due process. DRM also works to increase access to competitive and integrated employment, challenge housing discrimination, and increase access to inclusive education and access to voting.
Our services, inform and referral, individual advocacy, legal reputation, trainings, and assists with self-advocacy, outreach, and monitoring. How to request assistance. Call to schedule a intake at 1-800-452-1948 or 207-766-7111 or submit a online intake. Learn more about what to explain and contact DRM at the website www.drme.org or screen this QR code and I'll send you to the website. What is a DS grievance? A DS grievance is a complaint. A grievance is a base right for a person with an intellectual disability, autism, or an involuntary brain injury. You can give grievance anything that the department or your development services provide is or is not doing that affects your life.
And one exception to that is you cannot file a grievance disputing your eligibility for developmental services. That has to happen through a different appeal process.
Who oversees the grievance process? The Department of Health and Human Services, known as DHHS, oversees the grievance process. Maine law requires DHHS to originally train on grievances and to make plain language information on grievances available to people served by the department. DHHS must provide a one-page form to begin the process, but using this exact format is not required. For example issue, staff in a client's group home has told the client they cannot have dinner until 6 p.m. and they must eat what the home has scheduled for dinner.
And so on the slide, we have a screenshot of what that form looks like that can be found on the department's webpage. It is a one-page fillable form that asks questions such as the client's contact information, the agency's contact information, as well as the case managers, and then asking about what the problem is and what the client wants to happen.
How do I file a grievance? There are 3 levels of grievance. Level 1 is like the basic grievance that you and the caseworker and the client works together to file the grievance and see if the case manager can help resolve the grievance. If the grievance has not been resolved, it goes to a level 2. And that is the OADS program administrative level. Then the level 3 is the formal administrative hearing.
So thank you, Kyle. He did a great job of going over just kind of the overview of DRM and the grievance process. And so now I'm going to step in and kind of go through step by step for anyone who is looking to complete and file a grievance, either on behalf of themselves or someone they represent. So as Kyle mentioned, the first step is filling out that one-page grievance form. And we have linked to the department's website where you can access that one-page fillable PDF. As stated, the only information required for a grievance is the client's contact information, what the problem is, and a requested solution to that problem. A client can complete the form themselves, or they can make a verbal grievance and ask that their case manager or provider fill out the form. Once filed, it institutes a stay in services. So that means if a grievance is filed, there can be no changes in that individual's developmental services until the grievance process is finalized and has completed itself. The case manager should be the one to assist the client in sending out the completed grievance form to the parties involved. If the grievance is against the case manager themselves, the case manager supervisor should assist the client in filling out the grievance form. The case manager is required to document the grievance and notify Disability Rights Maine via email at dsgrievance@drme.org. Once sent out, the case manager should work with the client and the adversary to resolve the complaint. It's really important to remember at this step to document every step taken to try and resolve the issue at the case management level. So when the team met, what were proposed solutions? Why were they not available? So really documenting everything that takes place at that case manager level. If that grievance is not resolved within 16 calendar days, it should progress to a level 2. So the level 2 is the OADS program administrator. So if the disagreement was not resolved at that level 1, the case manager will send the grievance to the appropriate OADS program administrator. At this time, the case manager should notify you, your representative, and Disability Rights Maine via that same email address that the issue has moved to a level 2. And I do want to note that just because Disability Rights Maine has been copied on a grievance being filed does not mean that Disability Rights Maine will be taking that on as a case and representing the individual. If additional assistance is required, please reach out to us for an intake. The program administrator, once they receive the level 2, has 30 calendar days to try and fix the issue. The work to address that grievance may include a review of the documents, The program administrator may speak directly to the client or their representative about the problem, or they'll speak to the other parties involved regarding the grievance. For ease of access, we have created this slide that lists all of the current program administrators and what counties they represent, their first and last name, and the email to contact them by. These are all accurate as of April 4th, 2025. And so if needed, you may have to search additionally if any changes happen, but DRM will do our best to continue updating this list as we move forward. So the level 2, still at the OADS program administrator level, you will receive a written decision within 30 calendar days after they get your level 2 grievance. The decision in writing should tell you what the grievance is about, the program administrator's understanding of the issue, the program administrator's decision, and the reason for the program administrator's decision. And we really want to stress that you have the right to the decision in writing. So even if you receive a phone call and they tell you what the decision is going to be, make sure you get that in writing. It's very important for your due process rights. If the level 2 grievance the decision is issued and you are not happy with that decision, you have the right to escalate it to a level 3 formal administrative hearing. Level 3 grievance is considered an appeal of the decision from level 2. If you disagree with the level 2 decision, you will have 12 calendar days to ask for a level 3 resolution. So this means that either you or your representative should write a short letter explaining that you want to file a grievance about the grievance decision and why. We consider it at DRM more of an appeal, but the department does use the language that you were kind of grieving the grievance decision. If you do not receive a decision from the program administrator within those 30 calendar days of them receiving the level 2 grievance, you can also go right ahead and ask for the level 3 hearing. After 30 days, you don't have to wait for the decision. You can escalate it to the next level. So a request for a level 3 hearing must be in writing, addressed to the case manager and the OADS program administrator in your area, and it must be made within 12 calendar days of receiving the level 2 decision, or after 30 calendar days of not receiving a decision. So what is a formal hearing? Although an administrative hearing is more formal than the first 2 levels, it is a lot less formal than going to court. A hearing officer will be assigned, and they may contact you or your representative and OADS before the hearing. That will help them to determine where the hearing will take place, what facts people will want to share, and what topics will be discussed. This is a great time if either you or your client need any accommodations to attend the hearing. This would be a very appropriate time to bring up what those accommodations are. So what to expect at the level 3 administrative hearing. So typically in these situations, the department will speak first and explain their side of the story and call any witnesses they may have. After they are done, it is then the client's turn and their representative's turn to share their point of view and present documents and witnesses to support their case. Both sides of the dispute may object to any information given. Once both sides have had an opportunity to share their point of view, the hearing officer will recommend a decision to the commissioner of DHHS. This decision would be shared with you, your representative, your case manager, and the OADS program administrator, as well as the OADS central office. The department actually has a really wonderful frequently asked questions page regarding the administrative hearing process that we have linked on this slide that we highly encourage anyone who's entering that hearing to review, as we believe it gives a really good overview of what to expect. So some things to keep in mind. If you do not agree with the commissioner's decision after that level 3, you can appeal that decision to the main superior court, and you have 30 days to make that appeal request. As you go through the grievance process, you can always continue to work with your case manager to resolve the problem. So while the grievance process is going, you and your case manager and the other parties involved are more than welcome to continue to meet and try to resolve the grievance issue. If something needs to be done quickly, you and your case manager can look for a temporary solution. But if you can't find a temporary solution, then nothing will change until a final decision is made about your grievance. So that's really talking about that stay in services. So again, once a grievance is filed, nothing can change about that person's services until it's been completed. Mediation. So mediation is also available as a way to try and resolve the grievance. It's a way to help people solve problems or disagreements. A mediator is someone who has special training to resolve issues. They will listen to both sides to help them understand each other and try to find a solution that everyone agrees with. You can ask your case manager for mediation at any time during the grievance process, even if you've already filed the grievance. What requesting mediation does is it actually stops the grievance time limits while you try to reach it. So let's say you've escalated it to that level 2 ODES program administrator, and they have 30 days to issue their decision. However, at day 15, your client requests mediation. That means that that time limit of that next 15 days stops, and the client and case manager and adversary should focus on trying to resolve the issue through mediation. If it cannot be resolved through mediation, you inform the ODES program administrator and the timeline continues. So in the case I referenced, the program administrator would then have 15 more days until they issue their decision. So involving Disability Rights Maine. As I mentioned before, the rules require grievances be sent to DRM, but that does not guarantee we'll be assisting in the matter. If you would like to request advocacy assistance for filing a grievance or representation in the level 3 formal hearing, please contact Disability Rights Maine to schedule an intake appointment. And you can either do that through the phone numbers listed, or we have linked to our online intake form. DRM cannot guarantee that we will take on every grievance, no matter. However, we will always be happy to provide additional information. Also recently, the department did update their DS Grievance webpage, and they do have some helpful videos of themselves. So feel free to visit ODE's Developmental Service Grievance website for additional information, including more video tutorials on filing a DS grievance. And I have a link to that new webpage here. As always, we conclude our trainings with a survey. So if you have some time in your schedule, we always are welcome to feedback and would love to know your thoughts on our training here today. As always, if you require Disability Rights Maine's help, please reach out to us and schedule an intake appointment, and we will do our best. Thank you so much.